as usual, of course, and red. So now we're on YouTube.
All right. Welcome everyone to the quarterfinal match of the Hague Inter-University Law Debate Tournament. So today's match is between the Western University from Canada and University of Lagos from Nigeria. The topic of the match was given to the teams 10 days prior. Today's debate statement is, due to the rise of space tourism and traffic, a new international space treaty is needed. So the two teams have prepared for this topic for both sides, and after the introductions, we'll draw the algorithm to determine which position will be assigned to which team. So today, the host of the match will be myself, Anna Maria Urbanova, and my colleague, Mr. Aureliano Laurent. There will be a notification given to each team, a yellow card when you have 30 seconds remaining, and a red card when your time is up. So when you see a red card, you can conclude your sentence, but please don't start a new one. All right, and now for the introductions, I would like to give the word to Ms. Alonge Gloria.
Okay, good evening, everyone, from my side. My name is Alonge Gloria Ozio. I'm a fourth-year law student at the University of Lagos, and I'm really looking forward to a fruitful debate. Thank you.
Thank you very much. Mr. Parabek.
Yeah, my name's Dylan Perelbeck. I'm from Western University. I'm in my second year, and I'm very excited to get this debate started.
Thank you. Ms. Njoko?
Hi everybody, my name is Augusta Chobam Njoku, and I'm a 400 level law student at the University of Lagos, Nigeria.
Thank you very much. Ms. Hawa?
Hi everyone, my name is Megan Howa. I just finished my first year at the University of Western Ontario, and I'm very much looking forward to doing this debate with you all.
Thank you. Mr. Adedayo Michael?
Hi, good evening, everyone. My name is Adedayo Michael. I'm a second-year law student at the University of Lagos. So it is going, of course, to be a great debate. I look forward to it with you.
Thank you very much. And Ms. Ryberg?
Good afternoon to everyone from this side of the world. My name is Justine Drybra. I just finished my first year at Western Law School, and I'm really looking forward to today's debate.
Thank you very much. And for today's match, the coach of the team from Western University is also present for this match. So if I can give the floor also to Professor THIULDT.
Hello, everyone. My name is Valerie Osterveld, and I am the coach at Western Law, and I'm also an international law professor. Good to meet you.
Thank you very much. I'll share my screen in a bit to draw the positions. Right. So as usual, there are two options for each team to get either pro or against position. So a bit of anticipation. And for today's match, Western University will be defending the statement assigned for today's match in favor. And the team from University of Lagos will be defending the position against. Right. You will now have 5 minutes to finalize your preparations, and afterwards we'll start with the opening statement by Western University. Thank you, everyone. The time for preparation is now over. We'll be starting the match, and the Western University has the floor first. You have 4 minutes for your opening statement.
Before I begin, can I confirm I'm audible and visible?
Yes, loud and clear.
Perfect. Good afternoon to our judges, and good evening to my colleagues at the University of Lagos. Today, my colleagues and I will be arguing that due to the rise of space tourism and traffic, a new international space treaty is needed. Until recently, space travel was reserved for country-funded space agencies and was considered the domain of governments. However, in recent years, there has been a steep increase in space tourism and space traffic. Stephen Freeland, in his article, Fly Me to the Moon, defines space tourism as any commercial activity offering customers direct or indirect experiences with space travel. Virgin Galactic Space, SpaceX, Blue Origin, Space Adventures, and Orbital Assembly Corporation are just a few of the corporations currently offering or planning to offer space tourism experiences. There are currently 5 treaties on outer space. They are 1, the Outer Space Treaty, 2, the Rescue Agreement, 3, the Liability Convention, 4, the Registration Convention, and 5, the Moon Agreement. These 5 treaties are commonly referred to as the 5 United Nations Treaties on Outer Space. However, all of these treaties were adopted in the 1960s and 1970s, long before travel by private individuals into space for their own purposes was even contemplated. Therefore, a new treaty is needed to adapt to the changing times. Firstly, a new treaty is needed to clarify the dividing line between Earth and space, as there are currently no international agreements on where space begins. It is therefore unclear where international air law ends and international space law begins. Secondly, a new treaty is needed to clarify responsibilities owed to and imposed upon paying customers. The rescue agreement provides that there is a responsibility to rescue astronauts in peril. However, this agreement was drafted before space tourism existed. Therefore, it's unclear what responsibilities, if any, there are to rescue paying customers in peril, since they are not astronauts. Thirdly, a new treaty is also needed to set a space traffic management system, similar to the tracking system we have on Earth for aerospace law. A new treaty is also needed to set appropriate safety standards on an international level, instead of relying on the goodwill of domestic laws. Additionally, a new treaty is needed to redefine liability to fit within the times. The current treaties restrict claims to only be brought by states, when we should allow space tourists themselves to claim compensation. And finally, given the greater pressure on Earth's environment and rise in space debris that space tourism will inevitably cause, a new treaty is needed to minimize the impact on the Earth and space environments. Today, Megan will be presenting our first argument. That with the rapid rise of space tourism, the current lack of space traffic management requires a new international space treaty to ensure the safety of all involved. Secondly, Dylan will be arguing that without a different treaty to regulate international space law, the international community creates a dangerous environment that will be exploited by corporations. At the end of our submissions, it will be clear that due to the rise of space tourism and space traffic, a new international space treaty is needed. Thank you for listening.
Thank you. Now, University of Lagos, you may continue with your opening statements. You have 4 minutes.
Before I begin, am I audible and visible?
Loud and clear.
Thank you very much. Once upon a time, the provisions of the international space treaties were considered to be excellent. But those days are long gone. And after years of experiments and more groundbreaking technological advancements, we have learned a great lesson. When it comes to space travel, a treaty cannot survive the test of time. Ladies and gentlemen, good evening. My name is Augusta Chiwobam Njoku, and I strongly disagree with the topic that due to the rise of space tourism and traffic, a new international space treaty is needed. My argument is divided into 3. 1, a new space treaty will become redundant. 2, the issue of acceptance. And 3, the authority of states under the Outer Space Treaty. Moving on to my first point, a new space treaty will become redundant. Ladies and gentlemen, it is clear that just like the existing 5 space treaties, a new international space treaty will certainly go out of touch with the realities of space travel in the years to come. Rather than creating a new international space treaty, we propose that to address the rise of space tourism and traffic, the United Nations Committee on the Peaceful Uses of Outer Space should introduce an annex to the existing Outer Space Treaty. This annex will contain standards, recommended practices, and implementation procedures for regulating space tourism and traffic. Annexes have proven to be effective methods of catering to new subject matters that are absent from treaties. For instance, when maritime traffic started to rise, the International Maritime Organization included an annex to the FAO Convention, and this has facilitated the smooth running of international maritime traffic for decades. This shows that a new space treaty is highly unnecessary, and what we need is an annex. Secondly, the issue of acceptance. Recall that under the principle of state sovereignty, for a treaty to be binding on a state, the state must consent to be bound by it by signature, ratification, or other means as stipulated by Article 11 of the Vienna Convention on the Law of Treaties. Ladies and gentlemen, the Outer Space Treaty has been in force for 55 years, and yet there are still 84 countries that have not ratified it and are not bound by its provisions. Also, the Moon Agreement is generally considered a failed treaty because it has not been ratified by any country that engages in space exploration. And according to the United Nations Office for Outer Space Affairs, only 4 countries have signed it. Clearly, The bureaucracies involved in making a treaty binding make treaties an unworkable mechanism for monitoring the continuously rising phenomena of space tourism and traffic, and therefore we reiterate that a new space treaty is not a necessity. Thirdly, the authority of states under the Outer Space Treaty. Ladies and gentlemen, the Outer Space Treaty itself, the world's basic framework on international space law, provides in Article 6 that states have authorization and continuous supervisory powers over the activities of governmental and non-governmental entities in outer space. Following this authorization, the internationally recognized best practice has been for each state to create their own space laws governing their outer space activities, including space tourism and traffic. For instance, the United States recently set an example for such specific regulation with its Commercial Space Launch Amendment Act of 2004, which contains explicit reference to spaceflight participants and enables additional license requirements for a launch vehicle carrying human beings. This kind of internationally accepted state practice has served as an effective regulatory mechanism for outer space activities for decades, and it lends credence to the fact that a new space treaty is unnecessary in light of the authority of states under the Outer Space Treaty. In conclusion, ladies and gentlemen, space tourism and traffic are fast arising, and what we need are solutions that will remain evergreen, such as the introduction of annexes and specific laws by state authorities. The world certainly does not need a new international space treaty that is bound to become redundant in the next few years. Thank you.
Thank you very much for your opening statements. We are now proceeding to the first rebuttals. Western University, you have 2 minutes.
I want to thank my opponent for her arguments. However, I must respectfully disagree. My opponent has argued that a new space treaty is not necessary at this time for the international community. But currently, there is not even an international agreement defining where space law actually begins. Although some legal scholars have currently argued the divider between air law and space law should be 100 kilometers above the Earth, it is not a legally defined limit. Given that space tourism from companies like SpaceX and Blue Origin seem to be focusing their flight destinations on this boundary line at the edge of space, it is imperative that there be a new international space treaty to clarify this most basic legal principle. This is especially true given that right now there is currently no international framework regulating space traffic management. Although the International Civil Aviation Organization currently provides a global situational awareness coordination system for airspace, there is not one in existence for outer space. At the moment, the International Telecommunications Unit is the only international organization playing a role in space traffic management. However, their expertise is focused on assigning orbital slots. They have no experience with launch activities or any specific rules for movement in outer space, which carries significant safety risks of navigating space debris, live satellites, meteors, and the growing number of spacecrafts that will result from the rise in tourism. Ensuring the safety of space traffic is in the best interest of everyone on Earth, not just those who make their journey into space. Neither the existing legal treaties nor the international organizations in place are prepared to provide a comprehensive regulation of space traffic. Therefore, it is imperative the international legal community act now and implement new overarching legislation while space tourism is in its infancy. Thank you.
Thank you for your arguments. University of Lagos, you now have 2 minutes for your first rebuttal.
Thank you very much. I would like to know if I'm audible and visible.
Yes, you are.
Okay, thank you very much. Honorable judges, our counterpart colleagues argue that the boundary of outer space is not legally defined, but we say that is not even consequential. However, according to the Federation of International Aeronautics, the command line is a generally recognized boundary between Earth and space, that is, anywhere between 60 to 62 miles from the ground level. Within a short time, when space travel begins in earnest, this threshold will become an internationally agreed custom because it is already becoming widely accepted. So we say this is not a problem, and if it were, a treaty is not necessary for this purpose. An annex would do just fine. The biggest case for our position is the uniformity which treaty brings, but they did not mention it explicitly. Nevertheless, we would like to say that uniformity of rules is good. But a treaty is not the best way to achieve it. Considering technological advancements, the low response of states to obligations under international treaties, and the issue of inflexibility of treaties in the light of unforeseen circumstances that pervade outer space. Therefore, we recommend annexes and national laws for the regulation of space traffic and tourism. We believe annexes and national laws are better because, firstly, annexes and national laws are adjustable to progressive technological realities, latest scientific discoveries in outer space, and specific needs of nations as they arise. An example of the flexibility we speak of is how US was able to amend in 2019 its laws to tackle the issue of contamination of space debris. Honorable judges, understand and note that annexes also have equal force to flow with any treaty. Secondly, note that US, China, Russia, and 80 other countries are yet to ratify the Moon Agreement and are not bound by it. Besides, as evidenced by recent real-life experiences, treaties amount to dogs without tooth and are only nominally binding, hence their force of law cannot be appealed to in this debate. We do not see how a violation of space treaty would attract commensurate consequences for powerful countries like the United States, Russia, and China. However, national laws and annexes to the existing treaties would together promise to regulate space law in a much more satisfactory and progressive way. Thank you.
Thank you very much. We are now entering the second round of rebuttals. Western University, you have 2 minutes.
Before I begin, I ask whether I am both audible and visible.
Yes, you are.
My colleagues at the University of Lagos, namely my colleague Augusta, and sorry if I mispronounced that, has talked about the redundancy of a treaty 55 years old because it'll just say the same thing and the issues will be that of 3 days. But there was an issue that currently exists that wasn't 55 years, that didn't exist 55 years ago, and that is of private space exploration. Corporations are racing to put as many satellites as possible into our atmosphere, and it is the responsibility of the international community to ensure the safety of both below and above the clouds. And with current international space law as it is, they're failing to do so. And it's not difficult to understand corporations. I mean, look at the US. It's the country with the most amount of space debris. And the leading case regarding company interests is found in the case of Schlensky v. Wrigley, that says that the duty of directors is to promote the best interest of the corporation that they serve. And the way that the lack of legislation only influences corporations is to develop lower quality satellites that will cause more space debris, leading to more profits for their shareholders and harm to the international community. There are currently over 20,000 known pieces of 4-inch wide space debris and are traveling faster than 24,000 kilometers an hour. If any piece the size of a ping pong ball were to collide with the International Space Station, it would be destroyed. $150 billion and all 7 crew members lost. The risk, the International Space Station, the lives of the crew, the increasing amount of space tourists, and the many satellites, it is unnecessary for the sake of corporate research, and it only increases the longer that the international community waits to adopt a new international space law treaty. Thank you.
Thank you. For your second round of rebuttal, University of Lagos, you have 2 minutes.
Am I visible and audible?
Yes, you are.
Thank you very much. Honorable judges, this is our case. The provisions of the existing UN treaties and other agreements on space law that are vague, inapplicable, and unclear only require annexes in national legislations where clarifications or contextual interpretations do not suffice, not a new treaty. Our counterpart colleagues argue that the existing frameworks do not provide solutions to the present issues at all. But we say no. What these treaties actually require are clarifications, corrections, additional provisions, and interpretations that are consistent with the world's present realities and their objective. Relying on the Vienna Convention on the Laws of Treaty, a contextual interpretation of some of the provisions of these existing treaties in ways that are not unreasonable and inconsistent with the objective would suffice in extending them to space tourism. For example, a contextual reading of Article 10.1 of the Moon Treaty does not forsake space tourists, but consider them as astronauts, thereby making them eligible for protection under the rescue agreement. Besides, the objective of the rescue agreement is humanitarian in nature and would suffice in saving anyone who is in danger. Also, on liability, we say the Outer Space Treaty and the Liability Treaty provide sufficiently for liability. For example, Article 6 and 7 of the Outer Space Treaty put under supervision of state activities of non-governmental bodies. As a result of this, these private individuals are responsible to their state, and by extension, the states are responsible to the international community. We think this is sufficient in terms of liability. We strengthen our argument, honorable judges. We say that our counterpart colleagues have already conceded to the fact that treaties actually lose touch with reality. They did not consider it. They did not argue it. But we believe that a new one is still going to become obsolete. Therefore, we argue that it is more practical for states to enact national legislation on space tourism and traffic. We believe that this is capable of solving the problems that presently exist. Also, for the sake of uniformity, we suggest annexes to the already existing treaties on the international level in order to tackle the issue of space tourism, space debris, and the legal status of these tourists. We think these are very much more practicable as this allows for flexibility. Thank you very much.
Thank you very much. We are now entering the conclusions of today's match. Western University, you have 2 minutes for your conclusion.
I will now state our conclusion for why international space law is needed due to the rise in space tourism and traffic. Our first speaker, Justine, has outlined the need for a new international space law treaty to address the responsibilities of differing parties and to create a better system regarding space traffic management. Our second speaker, Megan, has reiterated the importance of a proper space traffic management system and the shortcomings of the current legislation. Myself, as our third speaker, has reiterated the inherent vices of corporation and the consequences of allowing them to remain unchecked. Space is humanity's final frontier. And instead of the previous unmitigated expansion to the detriment and unnecessary suffering of so many groups, it is necessary that the international community learn from these mistakes and collectively work for the betterment of all of humanity. Western law asks that given the rise of space tourism and traffic, that the international community create a new international space treaty for everyone. On behalf of Western University, both Justine, Megan, and myself thank my colleagues at the University of Lagos and the judges.
Thank you very much. Now for the conclusion, University of Lagos, you have 2 minutes.
Thank you. Just before I start, am I visible and audible?
Yes, you are.
Thank you. The current space treaty was a response to the development of intercontinental ballistic missiles in the 1950s. Now, despite the fact that the Soviet Union's launch of the first artificial satellite in 1957 hastened proposals to prohibit the use of outer space for military purposes, the treaty did not become a reality until 1967. So I guess the question we should be asking is if we can afford to wait for a minimum of 10 years before space tourism and traffic is regulated, especially in light of the recent influx of commercial actors in space. My name is Alonge Gloria Oziru, and in 2 minutes, I will be giving a summary of the debate. Now, we have stated that we do not need a new space treaty because the process of negotiating treaties in general are extremely cumbersome. Also, the current space treaty was negotiated when the former Soviet Union and USA, two of the largest spacefaring nations, could see eye to eye. However, the chances of regulating or negotiating a new space treaty anytime soon is extremely slim due to strained relationships. Now, our counterpart colleagues' biggest assertions have been that a treaty is necessary to reconcile the laws with current realities and also because they are binding and for uniformity. However, treaties have to be ratified before they are binding. And considering the poor rate of ratification of the current space treaty, specifically the Moon Agreement, which has only 7 countries that have ratified it, we believe that this argument does not hold water. Also, on the issue of uniformity, we have alternatives like the creation of model laws, which will serve as the basis of national laws. In conclusion, there are numerous alternatives. We could extend the provisions of the current space treaty to space tourism and traffic management by wider interpretations. We can also make use of annexes and model laws. A new treaty is absolutely unnecessary. Thank you.
Thank you very much. This concludes the quarterfinal match between the Western University and University of Lagos. Thank you both for your preparation and for your execution of your arguments. So now a time a bit to decompress and perhaps to also reflect on the preparation for today's match. What do you think about your teams and the opposing team's performance? So I would like to give the floor to Ms. Dryber.
I thought this was a wonderful debate. I have to say that this was personally one of my favorite topics so far that we've debated. I think that it's a really forthcoming discussion, and I think that the opposing team, you guys did an excellent job. And yeah, no matter what happens after this debate, congratulations to both the teams for making it this far, and I wish whoever moves forward good luck.
Thank you very much. Mr. Adedayo? Or if there's a bit of luck, Ms. Alonge?
Okay, I'd like to say that this was one of the most challenging topics for me because space law was never really my thing. But I'd like to say that I really enjoyed the research work, and I think I found a new interest. So, and I specifically enjoyed the debate, so I thought it was very informative. So thank you, everyone.
Thank you very much. Ms. Hava, how did you find today's match?
Hi, everyone. Yeah, I just want to echo what my teammate said. This was definitely one of the most interesting and fun topics we've had so far. Obviously, I'm very proud of my team and the work we put in, but you guys were honestly incredible and a fantastic team to debate against. So if it's not us going forward, we're definitely cheering for you guys to win it all. You did an amazing job today, so thank you so much.
Thank you very much. Ms. Njoku, how did you find today's match?
First of all, the research was really tasking because there were so many materials to consider. There was a lot to read. But, well, putting together an argument turned out fine. And I think today's match was really interesting. And the opposing side also put in so much work. It was evident in their arguments. So well done, everybody.
Thank you very much. Mr. Parabak, what do you think about today's match?
I thought it was such a great match. They came with such energy and such great, smart, well thought out points. I thought they were very articulate. I thought they were very good at making complex topics, also boiling them down and being able to understand them as well. And I really enjoyed them responding to our arguments, and phenomenal match. Best of luck to whoever moves on. If it's not us, then you guys all the way. So thank you.
Thank you very much. And Mr. De Adedayo, what do you think about today's match?
Okay, so firstly, I'm very sorry. I had lots of network issues while speaking. I'm so sorry. So I missed most of the speeches, and but I do enjoy the match. I heard some of most of the arguments from our opposite side, I think, and I think they've done quite a good research. I enjoyed the match, and good luck to everyone. I wish you all the best in the next round. Thank you.
Thank you very much. And Professor Osterveld, as the coach of the Western University, would you like to give some feedback to the two teams?
Sure, I really enjoyed this match. It was at a very high level. I especially appreciated the passion that both sides brought to the match, and I feel that they were very evenly matched. So it's going to be very exciting, as my students have said, going forward. If Western Law doesn't win, then I think we're going to be cheering University of Lagos on all the way to the very end. Take care.
Thank you very much. And on the side of organization, just allow me to say it's been a pleasure to see you progress through the competition. As you might have noticed, the competition starts with relatively easier topics in group phase, and as the rounds progress, so do the challenges for preparation. So I really hope that you've enjoyed the competition. It's been not only a learning experience, but also a good connection opportunity. Uh, for the results, you'll receive them as soon as possible. So once we receive all 3 scores from the judges assigned for your match, you'll receive the results. And the team that progresses into the next stage will have 2 matches. So one will be in the semifinals, and the second one will be 10 days after the results of semifinals, and that would be either for the 3rd place or for the 1st place. So those would be already the ranking matches. And we really do hope to see all of you in the second and last official networking event of the competition. It will be happening in the 2nd week of the June. And it's a bit unique because it's not specifically just for the law debate tournament, but it will be an inter-competition networking event where you will start in a virtual environment with the participants from this competition. But afterwards, the initial announcements, you'll be able to also meet participants from our parallel competition, which is taking place as we go. So the week when your competition is not taking place. It's happening in French. It's a bit more general, so it's not specifically just for law, but it's definitely a good opportunity to meet universities and compare the experiences perhaps and further your connections in the academic world. On that note, I would also like to encourage you to submit your research in writing, and you can do so either as a post or academic piece, or you can make a larger article and submit it for a quarterly publication, or even for a consideration for Young Authors Conference, which will be taking place at the end of this calendar year. And for that purposes, I would recommend keeping an eye out for the Hague International profiles, as they usually announce when the new submissions are taking place. Once more, well done to all of you, and I would like to give the word to my colleague, Mr. Lavange.
Yes, so yeah, you did a great job, both of the teams, actually. It was indeed not an easy topic, and because it's not often as well taught in universities, or except in a master level. So yes, well done. Another element as well, if you want still to send, of course, your photo of the team, let's say your own team, is still possible, because it will be like a souvenir, and as well we can have it as well in records for the next edition as well. So yes, we'll have this last networking event. We'll have as well trophies as well at the end of the competition. So it means, of course, you get certificates after you end the participation to this tournament. But so it means every team members and the coach as well get a certificate. And but yes, concerning the trophies, so these ones are physical awards in the sense that yes, we ship by post the trophies to the teams. So there is a trophy for the winner, trophy for the second place. I mean the team who arrives in second place, and as well a trophy for the best oralist of the final, which is designed designated by vote from the judge in final. And finally, yes, there are also some other awards which are for the best, the most preferred match by vote. That is something which is done through the form that we send by email, and as well the most viewed match on YouTube. So it means, yeah, the match it could be any of the ones which happen during this competition until. Even until the final. So yes, you can as well make a choice on this aspect, just by encouraging your friends maybe to watch the match that you have participated to. So voila, so this is what we are preparing for the last weeks of this competition. Again, it was very impressive today, because of course we have seen the progression through different months now, and from the friendly match for some, and as well from the start of the competition. So yes, you have reached a very high level of critical thinking and as well research that we can see, and as well listening to the position. So well done, and of course, yeah, we will let you know the results in a few days, and we keep in touch. Voilà, that's all on my side. Yeah.
Thank you, everyone. Again, really good job for today's match, and we look forward to seeing all of you in June.
Thank you very much.
Bye.
Thank you.
Thank you.
Thank you. Bye.